Welcome to S&C's podcast series, S&C Critical Insights. Today we're talking about the recent publication of draft vertical merger guidelines by the DOJ Antitrust Division and the Federal Trade Commission. The draft guidelines would apply to mergers between companies involved in different levels of the same supply chain, and they are subject to change based on public comments that may be submitted through February 11th. I'm Sophie Vandergrift. I joined S&C as a counsel in the litigation group this past fall from the FTC's Bureau of Competition, where I conducted merger investigations and litigations. Here with me today is my colleague, Dustin Guzior, who is a partner in S&C's litigation group. Dustin's practice focuses on antitrust and intellectual property matters. To start, Dustin, can we talk a bit about the context surrounding the release of the draft guidelines?
So in 2010, the U.S. antitrust agencies issued updated guidelines regarding horizontal mergers, meaning mergers between competing firms. Since that time, the horizontal merger guidelines have provided a reasonably well-defined framework under which to analyze horizontal mergers, both when assessing risk in the context of negotiations and when advocating for clearance in front of the agencies. But the last time the agencies issued guidance concerning vertical mergers was 1984, and at least over the past decade, vertical issues did not seem to attract much attention unless there was a substantial and obvious problem. More recent events, including DOJ's challenge of AT&T Time Warner, suggested scrutiny of vertical mergers was intensifying and raised questions about the framework that would apply for analysis of vertical mergers. So we can think of the draft guidelines as a response to that need for clarity. With that context in mind, Sophie, what do you think will be the practical impact of the final guidelines?
I view this as having pretty substantial policy implications. From the time of their release, the horizontal merger guidelines have really been the agency's playbook for how to analyze horizontal transactions and make enforcement decisions in that sphere. And I think we could see the final vertical merger guidelines occupy a very similar role. So the specific framework that's enshrined in those guidelines could really have a meaningful impact in a number of ways. First, on how companies assess prospective vertical transactions in the deal-making stage. Second, the number and kinds of vertical mergers that are subject to lengthy agency investigations. And finally, which transactions the agencies decide to challenge.
Picking up at that point, beyond investigations, historically we've seen United States district courts look to the agency's guidelines to interpret antitrust law, particularly in the context of horizontal mergers. So I think we at least need to consider that the courts will do the same thing here. Remember that in AT&T Time Warner, Judge Leon noted several times that a vertical merger is not assessed under a well-defined burden-shifting framework like would be applied for a horizontal merger. So although the draft guidelines don't expressly provide a presumption of legality or illegality for a vertical merger, we at least need to consider that courts would decide to use the guidelines for that purpose, and thus the implications could extend beyond agency investigations. Speaking of the presumption of legality or illegality, Sophie, did it surprise you that the guidelines did not contain an express safe harbor or defined standards for a presumption?
So, Dustin, there has been a lot of debate about whether any new guidelines would or, in fact, should include a standard for when the agencies would presume that a vertical merger was either lawful or unlawful, like the horizontal merger guidelines do. There is no presumption in the draft vertical merger guidelines, but there is a screen for mergers unlikely to raise concerns, which parties or the agencies might use at the outset to explain why a detailed investigation is or is not warranted. As drafted now, the screen would look at two markets. First, the relevant market for a competitive effects assessment, and then the related market, which is either upstream or downstream to the relevant market. If the merged firm has less than 20% share of the relevant market and less than 20% share of the related market, then according to the draft guidelines, the merger is unlikely to raise concerns.
Based on your experience, Sophie, in practice, do you think the 20% screen will be used as a hard and fast rule for which mergers become subject to investigations? Or, like we say in the antitrust world, which mergers receive a second request?
This is an important question, and one about which I expect we'll see a good deal of commentary and debate. As written, the draft guidelines ultimately require a fact-specific competitive effects analysis, which is not a departure from the status quo. So I don't think the 20% screen would change that and create an absolute threshold for whether an investigation is conducted. But having said that, if the 20% threshold is exceeded, merging parties should probably be prepared to articulate early why the merger should not raise concerns. And in practice, this threshold could create situations in which agency staff need to provide a more detailed, thoughtful explanation if they do decide to close an investigation early. So, Dustin, in practice, exceeding the 20% threshold could create a situation in which a client at least needs to be prepared for the possibility of a second request and the work that that involves. But apart from the 20% screen, what other sections of the draft guidelines stood out to you regarding vertical mergers specifically?
I think there were 3 sections that stood out, even if none of them was all that surprising. First, there's a focus on the potential for the merged firm to foreclose rivals' access to an important vertical or to raise rivals' costs. Now, this is a question of both ability. Could the merged firm foreclose a rival's access or raise a rival's costs? And then a question about incentive, meaning would the merged firm find that conduct to be profitable? If the answer to both questions is yes, then the draft guidelines currently say that the merger has the potential to raise significant concerns if the magnitude of the foreclosure or raising of rivals' costs is not de minimis. So this is an issue on which the draft guidelines focus, and parties should be prepared to provide arguments as to why the merged firm would have neither the ability nor the incentive to engage in this conduct, and perhaps even be ready in the early stages of discussions with the agencies to propose contractual or other mechanisms that could lessen these concerns. The second point that stood out to me is that the draft guidelines state a theory that competition could be harmed if the merged firm will obtain access to a rival's competitively sensitive information. For example, you have 2 competing sellers of orange juice, and one of them acquires an important orange grove. In the context of supplying oranges to the now rival, the competitor could receive information about what its orange juice competitor intends to do with its business. So essentially, the concern articulated is that pro-competitive actions will be chilled because competitors will learn about them and anticipate them. I think this part of the guidelines has potential to generate confusion for at least 2 reasons. First, what kind of information will raise concerns? All competitively sensitive information or only certain types of competitively sensitive information? Second, would this ever be a basis for challenging a merger, or is it a problem that could always be addressed through construction of an information firewall? The last point that stood out to me is that the draft guidelines focus on elimination of double marginalization, or EDM, as a defense. 2 firms in a supply chain will each earn a separate margin before the merger, but post-merger, both of those margins will be essentially captured within the same firm. This is EDM, which could create incentive for the merged firm to reduce the end price and increase sales because that's the most profitable course of conduct for the merged firm. With focus on EDM in the draft guidelines, merging parties may consider engaging an economist so that they can provide the results of an EDM analysis early and persuasively in the course of the agency's investigation. Those were the 3 points that really stood out to me. But moving on from what the guidelines might do, Sophie, we know they are subject to change based on public comments. And are there any areas in which you think comments could be effective?
Absolutely. So 3 commissioners actually issued statements accompanying the draft guidelines, and 2 of those commissioners' statements specifically invited comments on what those commissioners view as some of the most critical topics that are at issue here. First, Commissioner Rebecca Slaughter, she abstained from the vote to issue the draft guidelines. Interestingly, she didn't vote against the draft guidelines because she believes that the Commission should replace the 1984 non-horizontal merger guidelines, which most everyone agrees are too narrow and not reflective of modern legal and economic thinking. So with that in mind, Slaughter issued a statement explaining why she abstained. And her statement focused on discrete issues that could be subject to comment. Her central concern is with the 20% screen, which she views as effectively a safe harbor. While Commissioner Slaughter accepts that market shares and concentration statistics are relevant to vertical merger analysis, she takes issue with the 20% figure, which she views as potentially arbitrary and without empirical support. Second, Commissioner Christine Wilson, who voted in favor of releasing the draft guidelines, also issued a statement, a concurring statement, identifying certain issues on which public comment could be particularly helpful. These included whether the guidelines should include a specific safe harbor, and if so, at what threshold. Commissioner Wilson also asked whether the agency's approach gives sufficient weight to EDM. Of course, the draft guidelines already recognize that EDM will play an important role in the agency's analysis. So the commissioner's question appears to be only whether EDM should explicitly be given more weight or perhaps factor into thinking about a safe harbor. So in sum, Dustin, the 20% screen, the appropriateness of a safe harbor, and the treatment of EDM appear to be at least 3 topics on which public comments could be effective. So Dustin, with significance of the final guidelines in mind, what are some issues you think could be most interesting?
I've had 2 issues front of mind since reading the draft guidelines. First, especially after reading Commissioner Slaughter's statement, there's a real question about whether the 20% screen is informed by empirical evidence. So what will the 20% screen mean in the real world? For companies that regularly engage in M&A activity, an interesting litmus test would be to look at their activity over the past 5 to 10 years and do a very rough cut analysis on which vertical mergers or mergers with vertical elements would have been caught by this 20% screen. This rough analysis could give us a sense of the degree to which the screen would affect M&A activity going forward and inform whether a company might want to submit comments. On the other side, if a company has experienced negative consequences from a competitor's vertical merger, it would be interesting to think about whether that merger would have been caught by the 20% screen and how that merger would have been treated under the proposed guidelines. On either side, this type of real-world evidence could be used effectively in a comment, either to advocate for a safe harbor or to advocate for lowering or raising that 20% threshold. Second, I think companies and antitrust lawyers will need greater clarity on what theories of competitive harm articulated in the guidelines are game enders versus addressable through behavioral remedies. For example, a contractual commitment for long-term supply in the case of a foreclosure concern, or construction of an information firewall when it comes to concerns about competitively sensitive information. Remember that around the time of AT&T Time Warner, the Justice Department took the position that behavioral remedies were disfavored and structural remedies were preferred. I don't think that elevates to the level of a policy statement, but if the Antitrust Division were to continue to hold that view, it could have very significant implications for the effect that the draft vertical merger guidelines or the final vertical merger guidelines will have on M&A activity. Here, I think public comments could be effective in alerting the agencies to the fact that they need to be thinking about remedies at the same time as they think about the guidelines that would apply to the analysis of the mergers. So, Sophie, this is an important topic, and there are a number of additional issues we could discuss, but I think we have reached our time for today. Thank you for joining me, especially to share some of your insights based on your experience at the FTC. And thanks to our listeners for joining us for S&C Critical Insights. If you would like more information about our practice, please visit us on the web at www.solcrom.com.